Page 14, they give you the actual case that sort of was the seminal case with regard to medical examinations. That's Calabretta v. Floyd. And essentially, we've already sort of covered this, but essentially what Calabretta v. Floyd tells us is that, again, without credible evidence sufficient to support a reasonable suspicion that the child's been, physically or sexually abused, the social workers cannot do a medical examination on the child without a warrant. And if they do, again, it violates both the child's Fourth Amendment right and the parent's 14th Amendment right. And frankly, the balance of the outline up to page 22 deals pretty much with warrant requirements and the specific cases that are that address the stuff we've already talked about here today. It's a good idea if you're planning on filing one of these lawsuits, actually get on Google Scholar, look these cases up, read them, and read the factual scenarios that are set out in advance of the court's reasoning and decision, and try to understand and see how your situation may be analogous to situations set out in those cases. Because that's going to help you determine what information should be put in your complaint. What a lot of people do that is sort of the death knell of a complaint is they put in a lot of superfluous material, extraneous factual material that really adds nothing from a legal perspective, but does distract from the story that otherwise would set out the two elements that we need to meet. So remember, it's a good idea to read those cases first, and as you're going through them, sort of think in your mind, how am I analogous to this situation? What facts do I have in my story that would meet what this particular case is looking at? And sort of make an outline of those facts, and when you put your complaint together, if the facts you want to put in there is not just essential to one of your elements, it probably shouldn't go in there. So remember, the pleading standard, at least in federal court, is that you have to put together a concise statement of the facts that support your cause of action. Concise means concise. So you need to cut out all the extraneous stuff, like it was cloudy on Tuesday and my dog ran across the street and my husband was yelling at me and I turned my back and my child fell off the counter. The only thing there important is going to be your child fell off the counter. All right, content of court reports. We're pretty much moving on completely now. I know I said this before, but now we really are moving on completely from the warrant requirement. Content of the court reports. Everybody here, I think, is aware that once the child's been taken, we filed a dependency petition. Now there's the child put in foster care or a temporary shelter somewhere else, and the court's going to have a series of hearings where the judge makes a bunch of decisions and forces you to go off and engage in a bunch of services and prove to the court that you're a good parent. And then over the course of that 6 or 12 or 18 months, there's going to be repetitive hearings. Every time there's a hearing, in advance of the hearing, the social worker is going to file what's called a addendum report or a status review report. And then at the jurisdictional hearing, they'll file a jurisdictional report. Those reports, depending on what county you're in, are not signed under penalty of perjury. If you're in LA County, they are, which is a good thing because it makes it a whole lot easier. But because remember the same rules that we talked about before about prosecutors losing their immunity when they sign something under penalty of perjury as a complaining witness, same rules apply to a court report that's signed under penalty of perjury. Okay. That deals with LA. Every other county in the state, I think, does not sign their court reports under penalty of perjury. If your events happened after 2010, you're covered by substantive, because we know that we can't go in and lie to court, whether it's on the record, off the record, in sworn statements or whatever. If we know, as a social worker, I know that the judge is going to rely on what I'm telling him, whether it's under oath or not, and he's going to accept it into evidence and make decisions based on it, I know I can't lie, and substantive tells us that. There's another important case, if Tamas, T-A-M-A-S, versus State of Washington again, Social Services Agency. And what they did is they sort of expanded the original rule that came about in 2007. They expanded it from lying in warrant affidavits to saying that social workers do not have immunity for either their reporting or their recommendations as well. So those are also now covered under Tamas. I think that was a 2009 case. T-A-M-A-S. This is all, I'll post this. It's actually not there yet, but I will post this stuff on the Faga Group's Facebook page. I just did a big brief on this. I have
Does that do something like back problems for spinal cord injury?
I don't know. Let's hold off on that.
Okay, the site again is Tamas versus?
Tamas is T-A-M-A-S
Yeah.
versus State of Washington Department of Social Services or Health and Human Services. I have to look it up. Some places call them different things. And I believe there's another area that we're actually very close to the end. There's another area that is sort of a cutting edge area. We don't do much in this area yet. The next one of these little seminars that we do, I'll try to get Esther Boynton to come. She's sort of the queen of the Casey Index issues, and for those of you that don't know what that is, it's the California Department of Justice Child Abuse Central Index. Essentially what happens is if you had a social services investigation and the social worker, for whatever reason, thinks you did it, you beat your kid, you killed your kid, whatever it is, whatever they accuse you of doing, if that social worker decides you did it, without a hearing, a court order, or anything else, she will report you to the California Justice Department for inclusion on their Child Abuse Central Index as a substantiated child abuser. So that's a whole other issue. I wanted to bring it up because it's something that if you have dealings with social services now, you're going to want to look into it because you're probably on the list. And the outfall of that is that if you remain on the list and say you have your kids back and you want to go do Girl Scouts or Boy Scouts, volunteer at school, be the soccer mom, whatever, if they run a background check on you, you will alert on it because of your inclusion on the Central Index as a child abuser, and you're going to be disqualified from participating in those events. So it's something that you're going to want to be aware of, something you're going to want to look at. The Ninth Circuit has held, and it was in Humphreys versus County of Los Angeles, and I believe it was 2010, that you are entitled to due process. You're entitled to a hearing to get off that list. And you know, the hearing officer may or may not go your way, but you're at a minimum entitled to a hearing to try to get off that list. So I think that pretty much, let me run through my notes, that pretty much covers everything that I hoped to get through today. Why don't we take like a 5-minute break? And if you guys, hold on, let's take a 5-minute break.